Yes, the big reveal.
With my learned friends' indulgence, we've done what we can across the short adjournment. I'm going to refer you to some provisions of the lease facility agreement, which is found in the supplemental bundle at tab 12.
Just, I'm sure you do it very elegantly, but I think it helps me just to know where we're going. Are we going to the fact that there is a point here?
My lord, yes.
And it's available on the documents we've got.
It's available enough, if I can put it that way,
Yep,
albeit
okay.
there are certain things which I can only ask you to infer by reference to what you see in these documents.
Yes, okay.
So it's divided 12.
And you were given, Mr. Prosser, such notice as you can at these points. I suspect you're saying.
I've spoken to
He's
him.
told me he's got a point.
Oh, I see. Well, maybe such notice as he could.
I hope that there's slightly more than that, but I
Okay, it doesn't matter, yep.
quickly ran through it. So 12, this is the Inmarsat 3 lease facility agreement. And if I can ask you within that to turn to bundle page 166. You'll see that this is a heading, termination or ending of leases. I just show you that for the heading, and I then ask you to turn to 178. And so this applies to all the spacecraft. In A, if any spacecraft is not delivered on or before the 31st December 1998, the lessee shall, by notice to the owner, thereupon immediately terminate the owner's obligation to purchase that spacecraft and lease that spacecraft to the lessee with effect from the date. And if it fails so to terminate, the owner shall, at any time after 31st December, be entitled so to terminate, and following termination, pursuant to this clause 9.05a, the procedure described in clause 9.022 shall apply, subject to a proviso. Now, just to go through the sequence, on delivery, that's defined on page 156 in a predictable way. That means in relation to an asset, the point in time when title to and property in that asset and risk of loss thereof passes to the owner in accordance with the purchase contract for that asset. And luckily that spells out such time being in relation to spacecraft, intentional ignition, etc. Yep. So then moving to page 173, this is 9.022 at the top of the page.
So which page?
Page 173, my lord.
So looking back. Yep. Yep.
In relation to an asset which has not been delivered, the owner shall renovate to the lessee the purchase contract for that asset, unless it shall already have been renovated or terminated. And then B, the renovation sum for the asset shall be payable in accordance with and claimed under the relevant sales agency agreement, and that amount or such lower amount as may in fact be paid by the lessee pursuant to the sales agency agreement for the asset shall be retained by the owner. And then the definition of renovation sum is on 162. And what that says is renovation sum means, in relation to each asset, an amount calculated in accordance with clause 4.02 of the sales agency agreement for that asset. Now, we don't have the sales agency agreement, but my recollection of that is that there's very complicated provisions as to how things will be valued in such circumstances. But,
yes, but what's material to your point simply is a procedure will apply under which a payment will be made.
A procedure applies, and then the last thing I was going to show you was in Inmarsat's skeleton argument for the Court of Appeal at page 8 of the core bundle. So that, no, it's not page 8. Page 18, I think. And the way it was put in that, and we say consistent with the documents that I've got to find in a limited time. Thirdly, in any event, Inmarsat, this is 49, submits that the MLA required INSO to launch the I3 satellites in order to avoid being liable to make increased payments to ABI. That is, as is common ground, the MLA provided if the I3 satellites were not launched, then the rent payable by INSO and any termination sum payable, etc., would be increased to reflect ABI's consequential loss of capital allowances. So I'm knitting together some things that go to the conclusion that the debate between the parties has been what are the contractually defined consequences that flow, and, for instance, the money that falls due from Inmarsat, rather than falls due from Inmarsat, rather than there would be a breach of contract, i.e., it's the sums that will be payable are defined, rather than being penalties for breach. Now, but by no means is that comprehensive, but I hope it's sufficient, Your Lordship, that the point is still alive for me. And if there's more needed, I suspect it might require something in writing after the hearing.
I haven't got properly in mind how all these different documents knit together. Those at tabs 11, 12, 13, 14 are all of the same date, are they?
Yes.
The contract we see at tab 10.
So that's the original purchase contract as, I think in that form, yes, exists. I'm just double checking whether that's an amended form. Certainly that's the original date of the contract. There might be amendments.
At this stage, IMSO is referred to as Inmarsat.
Yes, it's slightly confusing.
It's an added confusion. We've tried during the course of the hearing so far to
separate the two,
keep them distinct, and I've probably trespassed on that by talking about Inmarsat just now.
So coming to the package of the 20th of December 1991, the novation agreement obviously has different parties. But the lease facility agreement, the master lease agreement, and the lease schedule are all between the same parties.
If I can put it loosely, they all fall to be dealt with together. It was a sort of a mechanism, to use that phrase, whereby the leasing arrangements were put in place.
And just showing how I haven't got on top of the detail, you have a master lease agreement which then has schedules annexed to it or linked to it in some way, of which one is at tab 14. Is that right?
I think we've got an example at tab 14.
And the relationship between the lease facility agreement and the master lease agreement, or does one have to wade through the?
Again, I'm slightly reluctant, without the full material, to give you thing that tries to be too precise about it. They operate together, if I can put it that way.
Yeah.
We certainly had them all available, both in the FTT and the Upper Tribunal, and we did spend some time about how they interlocked, if you like. But perhaps rashly, when trying to cut down bundles for the Court of Appeal, we took the view that this court wouldn't perhaps be interested in the same level of detail.
Yeah.
So that, at the moment, you're saying that is enough to make the submission you want to make?
It's enough. Whether, Your Lordship, whether this court is sufficiently interested to ask me to fill in the blanks, which I'm unable to fill in now, I leave with Your Lordships and Your Ladyship.
Yes, but your submission is that the blanks are just dotting the I's and crossing the T's. The substance of the point is sufficiently made by the
I mean, the point that we understand we're meeting is not that we would be in breach of contract, but rather that in circumstances where that there would, for instance, be significant payments to make, as in the example in paragraph 50, then it's tantamount to a situation where there is actually a requirement.
Well, we'll have to hear how it's put. I can see the way it's put in the skeleton might suggest that, but I think that Mr. Prosser's primary way of putting it was that there was actually an obligation by the rather complicated route he took us through, and there would therefore be a breach if there were not a launch. Query by what date?
Well,
I think actually it was my inquiry about what date which prompted this all.
Yes,
There can't be a breach unless there's a date, or at least a reasonable time obligation.
and in which case the answer from us remains that there is not such an obligation, because there is simply contractual provision if you don't do.
There are consequences if you don't do it.
Yes.
Which is in some circumstances it might be thought to be a distinction without a difference, but not here.
Yes, that is the submission. but to expand that into full detail of what would happen in all sorts of different scenarios at different times, I suspect would require a further piece of paper.
Yes, we will decide whether we want to hear further submissions on that, in which case they'll have, or receive further submissions, in which case they'll have to be in writing. But we won't decide that now, so we have to hear what Mr. Prosser has to say. Thank you.
Could I just deal with that point straight away?
Yes, certainly.
I'm not sure, to be perfectly honest, I've understood it, because this isn't an argument that's raised by HMRC in their skeleton. And this isn't a criticism, it's just a confession on my part. The arguments in their skeleton are to do with this being a generalised obligation, and not one, therefore, that's within the meaning of the sort of obligation that 61.4 requires. But this is a very different point, which is saying, well, actually, there wouldn't be a breach at all in these circumstances.
Well, that might. Yeah. Well, let's not.
I'm not
That might. The one might be just be a refinement of the other. A generalised obligation. The point being made might be thought to be there isn't actually any specific obligation you can pin down. In which case,
okay. But
it comes to the same
it
thing.
needs to be filled out a little more than that, because the point, as I understand it now, is not so much that 7.03 doesn't operate, but it may not operate to give an entitlement to damages, because there are other provisions in the lease which provide for what's to happen in those circumstances. That doesn't mean there isn't a breach of 703 in my submission. And so,
Well, it may come round to whether 703 imposes an obligation in the relevant sense, capable of being breached.
well, the starting point is, what does 703 require on the face of it, my submission? And then it may be that there are other questions to do with other provisions of the lease that suggest that that isn't, after all, imposing an obligation, because the lease deals with those sorts of circumstances by way of payment provisions anyway. And the only point I'm making at the moment is, because this isn't a point that's ventilated in HMRC skeleton at all, I, to be honest, haven't got my head around that in any way.
Well, that's fair enough. If what you are saying is that even in this form, without the I's dotted and T's crossed, you want more time to think about it, I think we are agreed you should have it. And the obvious way in which you do it is produce written submissions on this basis, short written submissions, because you won't have to go into a lot of detail, pretty soon after the hearing.
But I would be grateful. But I would be grateful. I mean, maybe the answer is I can look at the transcript and see exactly how Mr. Gibbon puts it, and then respond to that. But I want to make sure I've understood his answer.
No, well, I thought that is the answer. If you were going to ask for Mr. Gibbon to reduce all that to writing, I think that's an unnecessary complication. Right. Well, we will. When we get to the end, we will rise. I mean, it seems to me the choice is between let you to do that, or if we want this, say, well, if there's going to have to be further submissions anyway, we will get Mr. Gibbon to do a more Rolls-Royce version with all the, I'm mixing my metaphors here, with all the I's dotted and the T's crossed,
Yep.
to which you would then respond, and that would just mean a bit more time.
Could I just raise one extra point?
Yes.
When Mr. Gibbon and I had a very brief discussion before 2 o'clock about this, I said to him, of course, my case is that it's after the nomination of the launch date that the question arises whether or not 703 is engaged, 7.03 is engaged. It's not at some earlier date. So there is a whole process here, but that includes a nomination of the launch date, and we haven't looked at any of that. You asked the question, I think, about when launch might take place. The agreement and the various agreements talk about a nomination for there to be a launch date, which obviously feeds into when
That's IMSO who specify.
IMSO will specify that.
Yeah.
And that fits in with obviously when the contractor has to be done by and move the thing to the launch site. And it's at that point, or not before that point anyway, that the question arises, what does clause 7.03 require? When I said that to Mr. Gibbon, he said, well, I don't know about that. So that I don't know whether that's relevant to his argument at all. That feature of the point that it's after the launch date has been nominated. Now, can I just sort of feed that into, if this all becomes relevant, given that that's not on the transcript, as it were, what Mr. Gibbon says about that, it may be that it's just down to me to make what I can of that point, or without fully understanding what Mr. Gibbon says about it. I don't know.
Well, I think that let's just leave it there for the moment. As I say, when we rise at the end, we will have a discussion, come back to you about what we expect and with what timescale. And we'll bear that point in mind.
So I don't propose to say anything about that.
No, well, that's obviously sensible. Unless my lord or my lady want to raise anything now for you two to be thinking about, let's just go back to where we were.
Yeah.
Doesn't represent they do. Right.
So where we were was that I was making actually much briefer than 40 minutes. If I can help you there.
You thought it might be, but good.
Yeah, actually, given that we're now 20 past, maybe not, but I won't be.
It's not for you. Won't be another 40 minutes.
No, I won't be. I was just making some very brief submissions in reply on section 78.1.
Yes.
And I don't think I can, there's no point in me obviously repeating my submission. So I think if I can go to a point Mr. Gibbon made where he said that the silence in section 78.1 about the question of market value, in other words, this X% point, is, he said, a significant feature.
Yes.
Now, my submission is that this question of is it X%, and I said this in my opening, doesn't arise simply where 61.4 operates. It's a more general issue that arises whenever, for example, section 154 operates.
You say, for example, I think Mr. Gibbon says that is really the only situation which would arise. He says the share and part provisions don't really take matters any further. But in a sense, you're good enough for you to say there's one.
Well, there's one case, and leaving aside for the moment, I'm talking about section 78.1 here, it arises under 61.4. So we've got two instances where more than one person has incurred capital expenditure, and the plant belongs to more than one person as a result.
Is deemed to belong to.
Yes, deemed to, absolutely. Well, it might belong to one of them, but is deemed to belong to the other, yes, absolutely. And if one goes back to the section 154 example, in other words, you've got the contributor contributing to expenditure, which is actually incurred by the recipient, if I can call that person R. 155 tells you about successions to the contributors trade. But if we imagine that there's a permanent discontinuance of R, the recipient's trade, then the question is, what is the disposal value that R has to bring into account? And if we complicate it slightly further and say, suppose actually that there's a succession to R's trade, it's a deemed permanent discontinuance, but that on any view section 78.1 is engaged, we have that question. What is the market value that section 78.1 is referring to in the circumstances where R has incurred some of the expenditure, but only some of it? Does R have to bring into account, and does the successor to R say that they have incurred capital expenditure equal to the full market value, or is it only a proportionate amount? Now that's an issue which arises irrespective of my interpretation of section 78.1. And it's true that the legislation is silent, but that should not be regarded as a pointer against my interpretation, because I've posited an example which on any view section 78.1 applies to.
Yeah, got the point.
The only other point I want to make about 78.1 itself is those words wholly and exclusively, and I maintain my argument that because those words are directed at provision, not at the incurring of expenditure, the fact that section 78.1 is silent about wholly and exclusively, again, isn't a pointer, because on any view, the successor will have provided in one way or another the plant. On my interpretation of provided, whether they've incurred any expenditure, it's obviously not a sale, but or simply put themselves in a position to use the plant without becoming the owner, on my case. That's what wholly and exclusively is focusing on. Have you provided it for your trade, wholly exclusively for the purpose of your trade? And in my submission, the successor will have done so in the ordinary case. Obviously, if they're doing it for other purposes as well, then they won't. But the fact that the legislation doesn't tell you how to determine whether the wholly and exclusively test is satisfied isn't a reason to say, oh, well, it wasn't thinking about deemed ownership, because it's not the deemed ownership that raises the wholly and exclusively point. It's the provision that raises it. So what I think the upper tribunal said was, well, if you had actual ownership, then that would give you some guidance to whether there was wholly and exclusively, because why do they own it? But my point is, wholly and exclusively goes to provision, and they provided it on any view. So the question is, why have they provided it? So it's not a pointer. And then, can I turn to the tail piece, which obviously is strictly part of section 61.4, but it's relied upon as, not, if I've understood HMRC's argument correctly, as a reason for saying 78.1 doesn't apply, but on its facts kind of thing. In other words, it's not as if the tailpiece prevented section 78.1 applying in this case. It's rather that it's an indication that section 78.1 can't apply to the sort of deemed belonging in section 61.4 because the provision, the tailpiece fits uncomfortably with the operation of 78.1. I think Mr. Goodman nods, so I've got that bit right. And my answer to that is, well, if we look at the tailpiece in section 61.4, if I can take you back to that in tab 9. On page 96. and it's the words from but as from the determination of the lease. Section 24.6 shall have effect as if, and so on. So 24.6 is all about bringing a disposal value into account. It's not about getting allowances, writing down allowances. It's a disadvantage, as it were, to have to bring in a disposal value. And what it's saying is, as from the determination of the lease, that disposal value provision should have effect as if the capital expenditure had been incurred by the lessor or not by the lessee. Now, let's suppose a case where on any view there isn't a determination of the lease. So, not obviously our facts, but suppose that IMSO had assigned the lease to Inmarsat rather than there being a novation. I don't understand HMRC to be saying when you have an assignment by the lessee of his rights under a lease, that's a determination of the lease. Let's assume that I'm correct about that the lease hasn't determined just because there's an assignment by the lessee. In those circumstances, what we've got is, but otherwise the facts are the same, you have a permanent discontinuance of IMSO's trade coupled with a succession and an assignment of the lease. In those circumstances, there's no doubt that IMSO or someone who's within the charge to tax otherwise would have to bring a disposal value into account in respect of their the plant, because there's a permanent discontinuance. We've seen that is an occasion of a disposal event, and the disposal value is market value. Now, leave aside what value. In any event, the point is the lessee has to bring a disposal value into account. Now, then you ask, does that tailpiece is that still capable of operating such that, as from the determination of the lease, some later stage, maybe years hence, when the lease does determine that Section 24.6 operates to require the lessor and not the lessee to bring the capital expenditure into account as their disposal value. That would be a very odd result, because that disposal value has already been brought into account by the lessee on the permanent discontinuance of its trade. So how Section 24.6 operates when you have a succession that doesn't involve a determination is, in my submission, very unclear. My submission would be that where you've got these two provisions, 61.4 and 78.1, both operating on their own face, that it's effectively section 78.1 which prevails, and the tailpiece simply doesn't operate. Because it would give rise to a very odd result if it did operate, to require that disposal value to be brought into account again. Now, then the question is, was there a determination in this case of the lease? Because I would accept my arguments about section 78.1 are about recognising that the predecessor is bringing a market value disposal value into account, and that 78.1, the purpose of it is to put the successor into that predecessor's shoes. If the tailpiece prevented that from operating in this case, then I could see the objection to the difficulty of how it could be said section 78.1 operates at all. So I submit that there was no determination of the lease in this case. And therefore, there was nothing to cause the tailpiece to operate so as it were to shift the possibility of a disposal value away from the lessee. Now, why do I say there was no determination? Well, first of all, I hope it's common ground that if you have just a change of lessee without more because of an assignment of the lease, that isn't a determination. I've dealt with that point. Let's suppose it's a different case where you have a variation of the terms of the lease between the lessor and the lessee, but as a matter of contract law, that variation constitutes a novation, the way they've done it.
Well,
a new contract. In other words, they tear up the old contract, they vary the terms, but they do it in such a way as to say, let's forget about...
sorry, I've always used the term novation in terms of new parties.
Okay, well then my concept of novation includes any case of a new contract. And obviously when you have
I think that's confusing.
Right, well then...
My lord, my lady may not agree, but that's,
I won't use that
an odd use of concepts of novation.
I won't use that expression. In any event, there's a new contract.
Well, there's a varied contract.
No, I'm going further than that.
I see the same parties want to have different, they want to continue, broadly speaking, the contract.
Maybe a longer term.
But they decide, they would have the option of varying the contract.
Yep.
Protocol saying we change this and change that. Yep. Or tearing it up and starting again, whole new contract with a new date and everything.
Exactly. So that
there's no... Okay. And they take the latter choice.
They take the latter choice. And that may be a very foolish thing to do, but let's stick with that if we could. My submission is that there is no reason why the tailpiece should operate in those circumstances. In other words, we know what the effect of the tailpiece is that at that point, it's the lessor who's deemed to incur the expenditure for the purpose of bringing a disposal value in, and not the lessee.
But hang on. Surely the whole thing about this is about the parties changing, not about the terms. Don't really matter, do they? So, as you say, it's probably a matter of form whether a change to the terms of the lease are done by what is described as a variation or what is described as a new lease.
Right.
I would have thought.
Okay, so if you're with me that far, that the expression,
yes,
let's assume you are, for the sake of argument,
yes,
that the expression, the determination of the lease, is not a wholly contractual concept in the sense that whenever there's a new contract, that is a determination of the old contract.
Well, the common law, we just looked at it substantive. You asked for what... I've come across this point in completely different contexts. Right. And the answer tends to be, it depends for what purpose you're asking the question.
Yes. My submission is, if you're asking the question, is there a determination for the purpose of a provision which has the effect of deeming the lessor to have a potential extra amount to bring into account as their disposal value, it would be odd if that were to operate in circumstances where the leasing arrangement continues. I mean, if you were to accept that this concept is a sort of a chameleon concept, it hasn't got a fixed meaning. It all depends on the purpose for which it's there, and that it's not clear. You would be entitled to look at what the minister said at tab 15, where he explained when this concept of determination of the lease was brought in, when he explained it's because the lessor is now in a position to be able to dispose of the plant, which is more valuable on account of the fact that the lessee has incurred the expenditure. In other words, I would submit what the minister had in mind by a determination was an ending of the leasing arrangement such that the asset, as it were, reverts to the lessor who can dispose of it for more. Now, what isn't in mind is a case where contractually the lease comes to an end but the leasing arrangement continues such that the lessor is not in a position to sell the asset, as it were, free of any lease. And that makes sense in my submission, that while the lease continues, there is no reason why the lessor should have to have the disadvantage of having that additional disposal value. He's not yet in the position to take advantage of it.
You'll have to help me a little bit with how I get there, I think, on the words of the tail piece. How would I have this fluctuating applicability?
I beg your pardon,
How would we get to this idea that sometimes you are caught by the tail piece and sometimes you aren't caught by the tail piece?
No, it's simply an interpretation of the word determination. That it does not simply mean a termination of the contract, full stop, such that if there's a replacement contract, then at the moment I'm saying with the same lessee, then that isn't a determination. And then effectively I put my first point and my second point together, that if we've had a change of the lessee by an assignment, we know that's not a determination. If we have a new contract with the same lessee, we don't have a determination. If we put them together and say, if we have a new contract with a new lessee, why should that make any difference? In other words, because at all times, the asset is still being leased, albeit to a new lessee. So if I can put it this way, why should the operation of the tailpiece depend upon whether or not there's an assignment of the lease by the lessee to a new lessee, or there's a novation? Of course, there might be all sorts of commercial reasons why the parties want to do it one way rather than the other. But why should the legislation be concerned about that difference, that contractual difference? So my submission is that there wasn't a determination of the lease in these circumstances, in our factual circumstances, such that if IMSO had been a taxable person, it would have had to bring a disposal value into account. And Section 78, there's no reason to say that that fits uncomfortably with the operation of Section 78.1. So now I come to briefly my submissions on Section 61.4 itself, as it were. And I will be very brief about that. What HMRC say about this expression incurred in the provision of plant? They say, and I've written down what Mr. Gibbons said, the nature of the expenditure is that it leads to belonging. And then he also said it's implicit that one should be moving towards ownership. But I ask rhetorically, how it is about the nature of transport costs, that they are incurred on the provision of plant if they are incurred by the owner, and not if they're not? What is it about the nature of them? In what sense can it be said that the transport costs lead to belonging? In what sense are we moving towards ownership? We've got an owner, it's true, but focusing, as Mr. Gibbon rightly does, on the nature of the expenditure, or as I think Lord Russell said, the effect of the expenditure, there's no nature or effect to do with belonging just because the owner incurs them. And Lord Justice Underhill at the very beginning said to me, well, aren't these cases I was about to take you to do with the case where there was a contract between the, let's say, the seller and another contract with the same person, I think this was, I may have misunderstood the question you asked me, for transportation. In other words, it was a package deal, as it were. Now, that would be a case where you could say it's all to do with belonging. You're getting the transport as well as, but...
You're just getting a sale contract where the seller, as is often the case, is required to deliver.
Yes, absolutely. Whether you have any transport costs there at all, it may be that they are split out, but in any event, there's no hint in my submission in Benodico that those are the sorts of transport or installation costs, and only those which qualify. Obviously, this is obiter.
It's obiter and in passing, especially. But there we are. Yeah. The answer is this isn't fully developed.
No, it's not fully developed. HMRC accept it, however. They do accept that in the hands of the owner, transport costs qualify.
Yeah.
Even though their nature or effect is not that it leads to belonging. And when Lord Justice Underhill asked Mr. Gibbon, do you accept this because it's obiter dicta of the House of Lords, or I think I may have remembered, or do you accept it conceptually? In my submission, if HMRC accept it, they've got to accept it conceptually. I mean, that is the consequence of accepting it. It isn't saying, because these are obiter dicta. If you're going to accept it, you have to, therefore, make it work in the conceptual framework. And you can't say, well, we accept it grudgingly, therefore it has to be the owner. You've got to make sense of it. Why is it that it's different if it's not the owner? And Mr. Gibbon has not done that in my submission. He has not explained why it's different. He's said it leads to belonging, but that's just simply not the case.
Would your analysis extend to, let's say, transport costs, installation costs, that talks about as well, really by whomsoever they were incurred? So if somebody pays the transport costs or meets the transport costs, if you're transporting a piece of plant, does that mean that all gets swept up necessarily in the as somebody's capital expenditure that qualifies?
No, absolutely not, because clearly there's more to getting allowances than incurring capital expenditure. So that we know from Section 24 that you have to satisfy a belonging requirement, and that is what 61.4 is doing. That is the function of 61.4, to deem B 24.1b to be satisfied. 24.1a is satisfied, but it's B that needs to be satisfied. But in the context of 154, for example, suppose that the contributor contributes to the launch costs. In the hands of the recipient, who has entered into both of the contracts for purchase and launch, we know HMRC accept that all of those costs qualify in the hands of the recipient. It's rather odd that the contributor, who's only contributed to the launch costs, should get allowances. In my submission. Whereas if you're not in the contribution regime, all bets are off. Why should that be? Why should Parliament have said, if you pay some of the expenditure on provision, you get allowances under the contribution regime. But otherwise, your expenditure has to lead to belonging, and you can't even get within 61.4 if you're a lessee. So my submission is that HMRC have focused on who incurs the expenditure, not on the nature or effect of the expenditure, and that's where they go wrong. Mr. Gibbon says if I'm right about 61.4, that it can extend to transport costs, then it operates in wider circumstances than previously thought. Well, than they previously thought, obviously, and that's why we're here. But all that he can say about that is that the Tax Law Rewrite Committee, which is a branch of the Inland Revenue themselves, or now HMRC themselves, had only rarely come across it. It was an unusual case. Well, fair enough, it's unusual, but that isn't a pointer to its interpretation in my submission. Mr. Gibbon didn't say, unless I misheard him, that if I write about 61.4, then we get in that impossible world where the lessee gets allowances because the plant is deemed to belong to him, to the exclusion of the lessor. That's a point they make in their skeleton. No, he didn't repeat it all, but he hasn't withdrawn it. No, he hasn't withdrawn it. Well, in my opening, I submitted the short answer.
Well, I think it follows then that you haven't really got a right to reply on it.
Oh, well, then I may...
If you have answered it in your statement.
Fowler para 27 is what I would say in response to that. And then...
I think actually what I just said was wrong, but then you've said
I've
what
made
you want
my
to say.
I've made
Yes,
mine.
yes, okay.
And then issue 3A, which is to do with requirement to provide. I don't think I can really add anything apart from reserving my position, if I may, in relation to this new point. Mr. Gibbon relied on the Enstone case. In his skeleton argument, he said that's only relevant to the second and third ways in which I put my arguments about requirement to provide. I had 3 ways in my skeleton, and I've only advanced one orally. I would submit that is the strongest of them all, and the upper tribunal accepted it. The other ways didn't rely on a legal obligation. Enstone simply says the concept of requiring involves a legal obligation. Well, yes, fine. So far as my first argument goes, I'm arguing that there was one. And then in relation to the chronological point, at what time must the lessee incur the expenditure? I mentioned before I sat down yesterday a section to do with when capital expenditure is deemed to be incurred, and it's not in the bundle, and I wanted to hand it up if I may, just to make good the point. It's section 159 of the 1990 Act. I think that could go into tab 10, which has got those sort of back-end provisions of the 1990 Act, but which also apply to machinery and plant.
Very well. Thank you very much.
And it's subsection 3. And subsection 3 of 159 lays down the general rule. I won't go through the exceptions, but an amount of capital expenditure is to be taken to be incurred on the date on which the obligation to pay that amount becomes unconditional, whether or not there's a later date on or before which the whole or any amount is required to be paid. So it's when you become unconditionally obliged to pay. So my example yesterday was, and let's imagine it's the HMRC's example of the display case. The lessee, as part of the leasing of the shop, promises that he'll provide the display case. He enters into, and he does so under a wholly unconditional lease agreement, which is going to commence in a month's time. The term of the lease will commence in a month's time. And in order to get himself ready to fulfill that obligation, he contracts with the seller of a display case. It's at that point that he contracts, assuming that's unconditional, that 159 deems him to incur the capital expenditure. So the question is, has he made a major error, as it were, because he would have got allowances if he'd contracted later, or perhaps made his contract with the seller conditional on the term of the lease beginning? Or is it okay because Section 61.4 is not bothered about that timing distinction? My submission is it's not bothered. Those are my submissions in reply.
We will rise and just decide how we handle the question of further submissions. Thank you.
Silence advice.
We think it remains to be seen whether this will turn out to be a useful exercise, but I think the safe course is to have the all singing, all dancing version. And what that means, Mr. Gibbon, is we will ask you as soon as you think you can, I'll ask you in a minute when you think this will be, to produce a note with, I fear, quite a lot of supporting documentation, as we were putting it, dotting the I's and crossing the T's of the submission you made at 2 o'clock. And perhaps also dealing with the point, for safety's sake, that Mr. Prosser made about notification dates for launch, the procedure for notifying of a launch date.
So particularly after that notification has been given.
Yes, so that we can just so that we can understand how it all works. Almost certainly, you won't have to make any further submissions. That will simply support, unless you discover it undermines, but it will support the submission you've made. So we're not inviting you to restate that, though if it's convenient to have a note, as it were, putting it all together and saying, which will inevitably, as it were, have to state your submission in order to show how it's supported, that's fine. But we're not inviting you to develop a whole new set of submissions.
The primary objective is to produce the material and direct your lordships, your ladyship, to the relevant.
Exactly. But if that involves having to restate your submissions to show which goes to which point, that's acceptable. Now, that'll be a bit of work. I think my opening bid is it would be useful to have it by by noon on Friday, which basically gives you the whole of tomorrow and a bit more time to do it. But I'm prepared to hear submissions that's just not realistic.
On purely personal matters, I have a family funeral to attend on Friday, so...
no, of course, we'll be sympathetic to that. I imagine that others in the team may be doing a lot of the basic work, but you've got to give your imprimatur.
I do. Let me just speak, if I may, briefly, without the course needing to rise. I'm just,
yes.
Just a moment or two. It's been respectfully suggested, could we do 4 p.m. on Monday, bearing in mind my complications, and that then gives the weekend when I will be back.
Yes, I think that will work. What we were then going to do was to give Mr. Prosser 3 days to respond, because although there'll be a lot of material there, it's broadly speaking familiar material, I don't suppose he has his fingertips. No, this is all material that was before the FTT and the UT, it's just got it excluded. And the point itself, I think, is quite a short point. So unless, again, Mr. Prosser tries to persuade us otherwise, I would hope we could have a response from him by 4 p.m. on Thursday.
Happy with that, yes.
We think without enthusiasm, Mr. Gibbon, but knowing things can sometimes go wrong, there may be some new point in Mr. Prosser's response, which you should be entitled to respond to. We will give you till 4 p.m. on Friday, if necessary, to respond to any point that you think is a misstatement or misunderstanding.
The judicial indication is fully understood, and I can't object to that.
Right. Well, we are very confident, both generally and having seen the whole way in which this appeal has been handled, that both sides will take a sensible approach to this, and we're most grateful. Very well. Of course, to spell out the obvious, therefore, we are reserving our judgment. I think I need formally to say what you're very well aware of, that means that in due course council will receive draft judgments. The purpose of the circulation of the judgments in draft is so that the parties can agree, if possible, consequential matters, and if they can't, can provide short written submissions so that we can produce a final order at the time of hand down. Also, of course, to draw our attention to any typographical or other minor factual errors. More generally, the parties are entitled to advance notice so that they can, as it were, prepare for final hand down, but that is a strictly limited entitlement, and if you want any further guidance on it, the recent decision of this court in the Council General of Wales will remind you of what is allowed and what isn't, and its consequences of who actually gets to see the judgment. And I won't attempt to frighten you with the consequences if you get it wrong. I gather the bar has already been sufficiently frightened. But it just remains to thank you both, and importantly in this case, all those behind you, for extremely effective both written and oral advocacy. Thank you.